Hey folks, if you are interested in the 293-page regulation or discussion of regulations put out by the ATF dealing with the factoring criteria for firearms with attached stabilizing braces, we have the person to talk to today, which is Stephen Halbrook, the most important famous Second Amendment gun lawyer in the United States for the last few decades. He is here with us today to break down what exactly is this new regulation, possible legal challenges, and what we all need to know about it. 293 pages, that's a lot to digest. Stephen Halbrook has already done it. It's going to be a real treat to talk to him today here at the Four Boxes Diner. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And of course, help us get to 100,000 subscribers. It'll make a big difference with the social media algorithm. Stephen Halbrook, welcome aboard. If for those of you who don't know who Stephen Halbrook is, you really need to know who he is. Stephen Halbrook is, I would argue, and I think everyone would agree with me, the most important Second Amendment scholar and historian in the last several decades here in the United States when it comes to the Second Amendment's right to keep and bear arms. The United States Supreme Court has relied upon Stephen's scholarship in multiple major Supreme Court cases. Stephen Halbrook has actually argued and won Supreme Court cases against the ATF and Department of Justice. So if anyone out there could talk about what is going on with these ATF regulations dealing with pistol braces, it's Stephen Halbrook, who's actually defeated the ATF in the United States Supreme Court itself. Beyond that, Stephen is the author of many, many major books talking about the right to keep and bear arms all across the globe, especially here in the United States. His most recent book, if you haven't picked up a copy, you should do so, is America's Rifle, the Case for the AR-15 that just recently came out. Stephen Halbrook, thank you for joining us at the Four Boxes Diner, and looking forward to talking to you today. It's going to be a real treat for our viewers.
Thank you for having me, Mark. It's a real pleasure to be on the show. We've got a lot to talk about in a limited amount of time, and we'll do the best we can to be concise.
That's right. We'll hit the highlights. So first of all, Stephen, what on earth is coming out here? I just read a 293-page document put out by the ATF regulating so-called pistol braces. Tell us what's going on here.
Well, a pistol brace is an attachment to a pistol that ATF originally approved of to assist handicapped shooters hold heavy pistols, like AR-type pistols. So it's an attachment that would fit around, protrude onto one's forearm and be attached by Velcro, so you could hold it out with one hand if you don't have the other hand or the use of the other hand. And it's evolved over time. A number of manufacturers have offered that for sale, and ATF has on multiple occasions approved of it, and now, lo and behold, ATF has flip-flopped and promulgated a regulation that redefines rifle so as to bring these pistols with braces within that definition of rifle. Now that's a big deal because a rifle with a barrel under 16 inches has to be registered under the National Firearms Act. So what ATF has essentially done by expanding on the definition of rifle is to have expanded on the definition of a crime that Congress passed and Congress defined and passed. So we have the definition in the National Firearms Act for what is a rifle is a weapon that is made or remade, designed or redesigned, and most importantly, intended to be fired from the shoulder. It fires only one shot per function of the trigger. So what ATF has done is added to that definition first a statement that if you have have a brace and you have a place on the brace that allows it to be fired from the shoulder, then if 6 different factors are met, we're going to call that a short barrel rifle, and which is required to be registered. Now notice the difference in language there already. Congress said intended to be fired from the shoulder. ATF takes away from that and says that this item has a surface that allows the pistol to be fired from the shoulder. Big difference between intended to do something, fire from the shoulder, and some device that allows it to be fired from the shoulder. So even though your intent may be to only put the brace hold the pistol, attach the brace to your forearm with Velcro or whatever, and fire it with one hand and not from the shoulder, even though that's your intent. What ATF has tried to do is to take from that definition, undercut it, and to say, well, if somebody could fire it from the shoulder, based on various factors that we're going to decide, then we're going to call it a rifle, and therefore subject to restriction if it's got a barrel under 16 inches. So essentially, ATF has tried to redefine and expand on the definition of rifle, which has criminal implications, and that's a no-no. What did we learn in the 8th grade civics class? You have Congress makes the laws, the executive branch enforces the laws, the judiciary interprets the laws.
Yeah, and the ATF is part of the executive branch. So what you're really saying, Stephen, and it seems to make sense, is Congress is supposed to define what are federal crimes. And here you have ATF coming along trying to expand on the scope of those federal crimes enacted by Congress. And the ATF, as part of the executive branch, is just doing it on its own without any, approval or vote by Congress. Is that right?
Yeah, that's right. There would be nothing wrong with ATF telling the public what it considers when it tries to decide or analyze whether an item is a pistol or a rifle. There's nothing wrong with that. But when they try to make this binding, in other words, they try to add to the regulation, and basically it's called a legislative rulemaking, and then they say we're going to prosecute people who are acting not in accord with this regulation. That's where it goes beyond the pale. And that's why this regulation, you're going to see a lot of pushback to it. There's already civil litigation going on, but in criminal cases, this is going to come up. If you're indicted for a crime like a short barrel rifle, the jury should get an instruction that's defining that crime exactly the way Congress defined it. It would be highly improper to allow the jury to be instructed by a definition that the executive branch made up. Look, the executive branch is prosecuting the case. Are you going to tell me they can make the law and then prosecute under the law? That's where this goes beyond the pale.
Well, Stephen, before we get into more details, and I want to break down this crazy regulation specifically in just 1 second, but I think we should just step back for a second. First of all, it seems to me that the ATF is trying to redefine rifle to be broader than it means under the statute, but they're doing it with respect to two different federal statutes. One is the National Firearms Act, and one is the Gun Control Act of 1968. Can you just briefly explain to us what's going on with respect to those statutes and the ATF trying to expand, and what do those statutes mean?
Right. The most important one in this context is the National Firearms Act. It's unlawful to possess a firearm that's not registered with ATF. A firearm is narrowly defined, and in this context, it means a rifle with a barrel under 16 inches. So that's the NFA, the National Firearms Act. The Gun Control Act, Title I of the Gun Control Act, short barrel rifle has implications in one criminal provision, namely you have to have ATF's authorization to cross state lines with a short barreled rifle. So that's the difference here, and those are the implications. As I said, the NFA is really the principle that governs, or that's most important here, because if you possess an unregistered firearm under the NFA, that's potential 10 years incarceration.
Stephen, what's most confusing to me, just big picture policy-wise, is I always thought when I hear the term short barrel rifle, short barrel shotgun, whatever, right? The idea when the NFA was enacted was we don't want these short barrel rifles out there because they're readily concealable. That was at least the argument when the NFA was passed, I believe, that they were worried about the concealability. But what's weird about what the ATF is doing here is it's actually going against their policy considerations, because if you take a pistol and you add anything to it, including a so-called pistol brace or stabilizing brace, you're actually making the firearm longer in a sense and less concealable, which seems to be a little bit inconsistent with the concerns of the NFA, which is we don't, in the Congress passed it back then. We're worried about concealable rifles, concealable weapons, and here you have something that makes it less concealable, and yet the ATF is trying to throw people in jail over this.
Yeah, just a footnote on 1934 NFA history. Short barrel rifles were not in the original bill as proposed, but pistols and revolvers were. And there was a member of Congress who was afraid that the term other concealable weapon would be applied to rifles. And so that member of Congress suggested, why don't we have a specific barrel length so my hunters in my jurisdiction will know that their rifles are not included. But then as the bill went through the meat grinder, pistols and revolvers were taken out. And then we ended up with this short barrel rifle definition, which nobody ever said at the time that short barrel rifles were used in crime. And in fact, so-called boys rifles, single shot 22 rifles, were possessed by the hundreds of thousands by basically children back in those days. These were 22 single shots. They were not used in crime. So anyway, we end up with this part of the statute, which, to be sure, the executive branch has to enforce it. But this raises the issue, because you've mentioned used in crime, concealability, and all that. It's far less concealable than a pistol, which is not restricted by the National Firearms Act. These rifles are used very little in crime. Now, ATF tries to say restricting these pistols with braces doesn't violate the Second Amendment because short barrel rifles are dangerous and unusual weapons, but they're really not. And in fact, they're in common use. Certainly, pistols with braces are in common use by law-abiding citizens for lawful purposes. There are millions of them. Even ATF admits that in its explanation of why it adopted the regulation. So you're going to see court fights about whether the Second Amendment is implicated here, as well as the issue of, can ATF even do this, expand on the meaning of a criminal statute?
Yeah, it does. Under the Supreme Court's decision in Heller versus the District of Columbia, they said that, handguns are protected arms under the definition of the right of the people to keep and bear arms. So now if you stick a stabilizing brace on it, somehow you've converted a constitutionally protected item into an NFA item. Apparently that's what the ATF's trying to argue here. Is that right?
That's right. And what is the criteria to determine whether it could be, it has the brace has a surface area that could be used to fire from the shoulder? ATF looks at 6 factors, which it made up out of thin air, and which are not implicated in the definition that Congress passed. The first one is the weight and the length of the entire pistol with the brace. Okay, how much weight? What length? They don't tell you. Congress was very specific when it said rifle with a barrel under 16 inches. Hey, you've got a tape measure. You can find out real quick. But when ATF says weight and length will be considered, how are you supposed to know what that is? Now, they originally had proposed a form. They called it form, I think it was 4999, typical bureaucratic number for a form. And that had specific weights and specific lengths. And they explained that they did not adopt that form because it was confusing. And it's even more confusing that you don't have this objective factors to consider. For example, another of the 6 factors is length of pull. So that's the distance between the rear surface of the brace and the trigger. And so if that's under a certain amount, it's considered a pistol. If it's more than a certain amount, it's what might typically be found on a rifle. But they don't tell us what length of pull they're going to consider. Now, they don't have authority to dictate that. But on the other hand, here you have it again. Like, we're not going to tell you what we're making illegal here. We're just going to consider these factors. Another one is marketing and advertising. How does a company advertise the item? Do they suggest, or does somebody suggest in some kind of YouTube that it could be fired from the shoulder? Well, how the heck are you supposed to know how somebody is advertising or representing a pistol with a brace to the public? There's no way you can know. And another one that just came out of the blue was, is the brace part of a device that's necessary to work the action of a semi-automatic pistol? I don't know where that came from. A semi-auto is a semi-auto is a semi-auto. So how that would relate to whether it's intended to be fired from the shoulder, I have no clue.
I want to break down this regulation just one second. Before I get to that, I noticed in these 293 pages of regulations, they keep referring to pistols, but they also have this other term that was sort of new to me, at least in the context of these regulations. They talk about heavy pistols. what is heavy pistols, and where did that come from? Is that just something that's used in the industry? Is it defined by some statute? But they talk about heavy pistols versus pistols. What's up with that?
Well, if you have like an AR-15 type pistol, it's relatively heavy compared to, let's say, a baby Browning 25 automatic pistol that would fit in your pocket. And so the original idea of the brace was to allow, as I said, a handicapped person to be able to hold the pistol with one hand because you don't have the use of the other hand. And to brace the pistol, to grip the pistol with your hand, and then to brace it, maybe with Velcro or some other way on your forearm, so it stabilizes it. That's the term want brace. And so that's something that's you would use on a heavier pistol. But if it's a very light pistol, it would be unusual to want to have a stabilizing brace. But
the bottom line is, the phrase heavy pistol actually in these statutes that the ATF is supposedly interpreting?
Well, no, not at all. I mean, the statute defines rifle. It doesn't actually define pistol. There is an ATF regulation that defines pistol, but no, I mean, heavy pistol, that's not something. A pistol is a pistol without regard to its weight.
Now, to help the audience, I read carefully the regulation, and I want you to confirm if I got this right, Stephen, and then I want you to go through some of these factors. But before I get to that, let me ask the Supreme Court decision, because I think this is a very important case, and I did not see, maybe I missed it, but I did not see the ATF in their 293 pages of discussion with countless footnotes. I did not see a discussion, maybe I missed it, but I didn't see a discussion of Staples versus the United States, a hugely important Supreme Court case dealing with semi-automatic rifles on the one hand and fully automatic rifles on the other hand, and when someone can go to jail for NFA violations of possessing a fully automatic weapon without having to be registered with the NFA and have the tax paid. So can you talk a little bit about this Staples versus United States case, this criminal case, and why it might play a role in dealing with this ATF regulation, whether it's constitutional or illegal under the APA or otherwise?
Right. So Staples versus United States held that the government has to prove your knowledge of the character of a weapon if the government claims that the weapon is one that's defined by the National Firearms Act. It has to do with the so-called mens rea concept in our tradition going back to the English common law. To show that you committed a crime, they've got to show that you had knowledge of why they think it was a crime. So, for example, in the context of Staples, it was whether Mr. Staples knew the firearm would fire more than one shot with a single pull of the trigger, and he did not because it was malfunctioning. And in fact, when you go back in that time period, ATF had ways of facilitating a gun firing more than one shot by using soft primer ammunition. This is another story I won't go into, but the bottom line is that Staples was basically acquitted because it could not be proven that he had knowledge that the rifle would basically malfunction and fire more than one shot per trigger pull. So applying that here, the knowledge requirement that Staples imposes fits in nicely with the definition that Congress already crafted for rifle, intended to be fired from the shoulder. The intent is already in the statute itself. And yet ATF is going away from intent and going to, is it possible that the rear surface of the stabilizing brace makes it where it could be fired from the shoulder. Could be is not the same as intended to be, and is certainly not equivalent to that you intend to fire it from the shoulder.
You're right, and the word allows in this definition really does it. So let's just look. So here's the definition of rifle that the ATF claims is now federal law once this goes into effect. So it looks to me as I read this, Stephen, there's really four things that one of these guns has to meet before it's an NFA item, but it's very confusing. So the first thing is it has to be a weapon right? Right. The definition of the term rifle is designed or redesigned, made or remade, and intended to be fired from the shoulder. And in order to meet that statutory definition, the first thing is it has to be number one, a weapon, right? So it's got to be a weapon. Then number two, that weapon has to be, quote, equipped with an accessory component or other rearward attachment, e.g. a stabilizing brace. So you got to be a weapon, and then you got to have a stabilizing brace. That's the second part. Then that stabilizing brace has a third component, which provides surface area that allows the weapon to be fired from the shoulder. So that's the third thing, right? Provide surface area that allows the weapon to be fired from the shoulder. And then you got to go to a fourth item, provided these other factors, and that's going to be a key word, Stephen, I think, other factors as described in paragraph 2, indicate. Now, notice they use the word indicate, not demonstrate, not prove. Provided that other factors as described in paragraph 2, which we'll get to in a second, indicate that the weapon is designed, made, or intended to be fired from the shoulder. And again, the word indicate doesn't say demonstrates or proves. It just says suggest or implies, which is what indicate means. Then you go down to paragraph 2, and then it gets into your point, Stephen. Then paragraph 2 is not like one paragraph. It's actually 6 or 7 paragraphs laying out 6 separate factors, which the ATF doesn't appear to be telling us how to weigh. Like, if you meet one of the 6 factors, do you go to prison? If you meet 2 of the 6 factors, do you go to prison? Do you have to meet all 6 factors to go to prison? And what do these things even mean? And one of the crazy ones, like you point out, Stephen, is factor number 5, talks about the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. Now, if I'm going to go to jail for possessing an NFA item, why am I being charged with the responsibility of knowing what some gun company did in its advertising or marketing on the internet or in California or wherever? How am I even supposed to know any of this? So Stephen, it seems to me, given the Staples rule that you have to have knowledge that you've got an NFA item in your possession to go to prison, how on earth can anyone figure out what this even means? Never mind, do they have the knowledge they have an NFA weapon based on these multi-factor criterias, which is not even clear how many you have to meet before you go to prison?
Look, the ATF considers not only manufacturer advertising, but if you look at the text of the explanation for why they're adopting all of this, there's a footnote where they're going into YouTubes by media, or who knows who, anybody can make a YouTube now, where somebody fires one from the shoulder. And they mention specific companies there whose products were used on those YouTubes. So this idea that company advertising is what they would consider, well, it's a lot broader than that. In fact, if you go to the 6th reason that follows that one, it's sort of like the general use as understood in the community. I mean, talk about vague, like how would the community, whatever that community might be, think about this and use it? And then going back, I've mentioned 5 of the factors. There's one more I want to mention. If you have a scope or sights on the pistol where you have an eye relief consistent with firing from the shoulder, then that's another one of these factors they would consider to think it's a short barrel rifle. So it depends on how your sights were set. Now, sights are set differently for everybody. Everybody has a different way of pulling the trigger, and the gun shoots a little bit left or a little bit right based on where your trigger finger is pulling it. So where your sight is, that's not an indication of firing from the shoulder. You might have it set in a way that with your line of vision, you would be firing it as intended, using it as a pistol brace. So you've got these 6 factors. As I mentioned, when they originally proposed this, they had a form which did have some objective criteria, like an actual weight and actual length and whatnot. And now they admitted that was vague, and now they've gotten it even more vague. And these are the factors they would consider, and then they prosecute you. You know, compare that with what Congress said, intended to be fired from the shoulder.
Well, Stephen, there's an old story about Emperor Nero in the Roman Empire that used to put laws high above the Colosseum, I think the story goes, so that ordinary Romans would not know what all the laws are. And as a consequence, it was very easy to put them in prison. I almost feel like looking at these regulations. Look, I'm a high-end lawyer. You're a high-end lawyer. We read this stuff and I'm thinking to myself, geez, I don't even know what the advice would be to the client other than to be very careful because it's unclear. By the way, do they even clarify how many factors have to be met before you go to prison? Is it one, Stephen? Do you have to meet all 6 of these Part 2 factors, or what the heck is going on here?
No, if they were prosecuting you, they would go into court, they would have an expert witness, and that witness would say what the weight is, what the length is, the line of vision, the optics, and all that. And then the person would want to offer an opinion and say, yes, this person intended to fire this from the shoulder. So that's not the way the law works. The law has to give you clear warning to avoid vagueness. And we have an exercise of a constitutional right here as well. Supreme Court in Heller said possession of a handgun is protected by the Second Amendment. And what ATF is doing here is redefining handgun to be a type of rifle. Well, guess what? Rifles and shotguns are also protected by the Second Amendment. So we're in a dilemma here, and you're going to see litigation going on and on from this. It was unnecessary to promulgate this regulation. It's something that's been growing in the weeds for some time. It was first proposed a number of months ago, and now here we have it, and it's going to be one more big splash and one more big mess. I want to get to what ATF says you can do to comply with their redefinitions, if I could at this point. So a rifle with a barrel under 16 inches requires registration under the National Firearms Act. So there's an easy way to comply with, if you have a real rifle, a real short barrel rifle, is take the short barrel off and put on a 16-inch barrel or 16 and a half, whatever, anything 16 or above that. And now you're in compliance. ATF is also offering you to register it under the National Firearms Act. Now, this is a statutory authorization issue. They're claiming it's a short barrel rifle, but there's no provision in the NFA to allow you to register a short barrel rifle which is unregistered. It can only be registered one or two ways for a private individual. One would be you apply to make the rifle with the short barrel, and you send the application into ATF on what's called a Form 1, application to make and register a short barrel rifle, and then after 6 months or whatever, they send it back to you and authorize you to make it. Here, if you bought the pistol with the brace, you haven't made it. So ATF cannot say it's doing this under that provision of the NFA. And the other provision of the NFA for you to get a short barrel rifle would be for the transferor, who would be a special NFA taxpayer, so-called, to get authorization from ATF to transfer it to you. Well, that's not at stake here either, because it's already been transferred to you. It's contraband. So, and then the other thing that ATF is doing, which is being nicer to the American people, is they're waiving the $200 tax. That would be the making fee or the making tax or the transfer tax. So they are allowed, when they change a ruling, to not make it retroactive. So there's a statute allowing that. So it's nice of them to do that, not to try to charge millions of Americans this $200 tax when they themselves had approved of these devices as not being NFA. A third thing you can do is to dispose of the brace, or you can make it where it won't fit your rifle, so you can't assemble it as a short barrel rifle, so-called. And the ATF cites the Thompson Center Arms versus United States case. That's a Supreme Court case that I argued and won, which basically says you can possess parts where you could make it something into an NFA firearm as long as your intent is not to make it into one, like a short barrel rifle. You can have a pistol and parts to make a pistol. You can have parts to make a long-barreled rifle. It's not a problem, even though you could make it into a short barrel rifle. So anyway, ATF does not faithfully describe the implications of that. If you have a brace that could go on another rifle that has a barrel 16 inches or more, why would you need to make it where that brace would not fit your original pistol that it fit. Then it gets unrealistic. You can surrender to ATF, like please. Nobody's going to surrender their pistol with the brace to ATF, or you can basically destroy it. Oh, right. So you're going to destroy your pistol and the brace. I don't think anybody's going to do that.
What's weird, Stephen, is they say repeatedly they're not trying to ban pistol braces. And then they go on to point out that they're saying, well, and this is the language that the ATF used. They said that, the Department of Justice has basically accused individuals and manufacturers of, quote unquote, circumventing the NFA. But how can one circumvent the NFA over the last many years when going all the way back to, I think, 2012? They've been signing off on a lot of these different types of so-called pistol braces and saying they're not short barrel rifles. How legally, Stephen, can the ATF literally do a 180 on a lot of these items and say, well, now you're a criminal, now you've committed a crime? And you've raised a crazy important question of if the ATF may not even have the authority to allow you to register these guns now because you're not making the gun, it's already made, and you're not transferring the gun. You're still possessing it. So you're even saying, does the ATF have the authority to do what it's doing in terms of the remedy here? So what is going on? How can they say that Americans have been circumventing all these laws when they're really relying on ATF historical interpretations, letters, and the like?
Right. I have a collection of letters that they sent to manufacturers of stabilizing braces, and also to manufacturers of firearms with stabilizing braces. And in fact, they summarize their own letters in this rulemaking that's not published in the Federal Register yet, so it's not quite valid yet, but on that date, the time will start ticking. But there again, you don't really know whether they would consider it to be a short barrel rifle. And that's why, we're lawyers, as you said, and how are we going to tell a client that, yeah, this comes under the law or it doesn't come under the law? So it's a real dilemma. This didn't have to happen. This ruling did not have to be promulgated, but now we have it, and so we have to deal with it.
Well, one of the interesting things I noticed, because I actually read the 293 pages, including the very, very last page, Stephen, you probably saw this too. This has been personally signed off by the Attorney General of the United States, Merrick Garland. I want to remind everyone on this channel that Merrick Garland, when he was nominated to the Supreme Court to replace Justice Scalia, was labeled a moderate, a milquetoast guy, a middle-of-the-road compromise, candidate that everyone can agree on is just a normal down-the-middle jurist. And here you have Merrick Garland signing off on really the expansion of the criminalization of millions of American gun owners potentially, and he's personally signing off on this regulation as the Attorney General of the United States.
Yeah, he used to be a judge on the D.C. Circuit. I had him in several cases. I could never get his vote if it was a firearms case. One of the cases had to do with the Second Amendment. Another case had to do with the extent to which ATF can keep records on law-abiding gun owners where they've been approved. I should say the FBI keep records, not ATF, under the NICS system. So, he was never moderate on gun cases, and he's shown his true colors on lots of other issues, I think, from parents of school kids to other issues in terms of this moderate image.
Stephen, you're a criminal defense lawyer, so you've represented people who have been charged with crimes. And I want to read something out of page 86 of the ATF's regulation here on pistol braces. And I want to know whether or not if you were representing someone charged with a crime for possessing a short barrel rifle because they took a pistol brace and added it to a pistol, would you be able to use this language in court on behalf of your charged client? This is what the ATF writes on page 86 of their regulations. They write, quote, while the department acknowledges previous inconsistencies and the resulting confusion regarding ATF's private and public guidance on firearms equipped with stabilizing brace devices, ATF never declared that the marketing of a device as a stabilizing brace when equipped on a firearm removes the firearm from the ambit of the NFA. Would you be able able to use, Stephen, that admission of previous inconsistencies and the resulting confusion thanks to ATF's own actions, would you be able to use that in a court of law to defend a criminal defendant charged with one of these crimes under the NFA?
I would sure try. I would want it on a poster in front of the jury. I would want copies of ATF letters approving these devices on big posters for the jury to read. Yeah, this is exculpatory evidence. This is evidence that indicates that the person is not guilty as charged. And you would, I mean, the whole idea, the inception of this regulation, President Biden wanted to do something about pistols with braces, which have not been a crime problem, by the way. And so they order the Justice Department, Merrick Garland, to do this, and he orders ATF to do it. This was not an inception of ATF to do all of this. It came down from the President and from the Attorney General, and then ATF obeys their commands. And that's the way the pecking order works. And so there's the whole idea that for years ATF approved of these devices and said that these pistols remain pistols with the braces, and now they flip-flop and say the opposite. And that whole idea that the industry is trying to circumvent anything when they have the approval letters is mind-boggling. And by the way, none of these approval letters are worth anything anymore. ATF says so itself, that you can't rely on the approval letters if you're like a manufacturer or like a dealer selling these items. They would have to be sold as NFA firearms requiring registration.
What's interesting, Stephen, to me is that if you look at what they talk about these 6 factors, I think it's important for the audience to understand. There's multiple parts here, but part 1 is really, can it be fired? Can it, not will it, but can it be fired? Can the pistol brace allow you to fire from the shoulder? But as I look at it on page 140 of the regulations, this is the language ATF uses, and it's, quote, ATF, quote, will not attempt to precisely measure or quantify the surface area or make the determination based on the existence of any minimum surface area. Instead, ATF will consider whether there is any surface area on the firearm that can, I repeat, can, not will, but can be used to shoulder fire the weapon. So here you have the words any surface area on a firearm that can, not will, but could be, can be used to shoulder fire the weapon. So it seems to me they're basically saying that any and all stabilizing braces automatically meet part 1 of this test, which means that every single analysis is going to fall or rise or fall on the 6-part test, of which there's no teaching of the measurement or how many you have to meet or how they weigh against each other, any of this stuff. So what's going on with that, Stephen? It seems like they're saying that anything that protrudes is going to be deemed a pistol brace under this law.
Yeah, think about the fact of how subjective this is, but it's considering a one-size-fits-all criterion. Think about the surface area, or think about length of pull, or the overall length of the pistol with the device. Where everybody's different. There's small people, there's big people, there's muscular people, there's weak people. And if you're talking about weight, for example, if you're a very strong person, it could be very heavy. If you're a person without so much strength, you might want something lighter. So how does all of this figure? Is there like one person at ATF who's going to be the perfect embodiment of a human being, where like the surface would be just right for that person, whereas it might not be very comfortable or very indicative of intent to be fired from the shoulder by another person who might have a lot larger area at the shoulder? So again, this assumes the one size fits all, but Congress didn't define it that way. I keep coming back to Congress said made or remade, designed or redesigned, or intended to be fired from the shoulder, and that relates to the intent of the person who has the pistol and brace.
Stephen, how many comments were actually submitted to the ATF as part of this proposed regulation? And do we know how they broke down good, bad, ugly, pro, con?
Yeah, I don't memorize these terms. I got to look at my note here. Oh yeah, there were 273,000. There were 237,000 comments filed, and guess what? Only 20,000 of those were in favor of the regulation, and they were mostly form letters that some lobby, some anti-gun group told people to write. But there were 217,000 that were opposing, and some of those were, of course, form letters too, but most of them were not. You had gun owners from all over the country opposing this regulation and explaining why it's not lawful.
So if you have 237,000 comments submitted as part of this regulation, and now we have a 293-page explanation of why ATF supposedly can redefine and expand the definition of rifle that ultimately can put people in prison, how do you think the courts are going to be looking at this, Stephen? It seems to me there's a lot of, strong legal arguments on behalf of people that think this will be unenforceable. Everything from they've exceeded their authority under the operative statutes to they don't have the authority to do the remedy they're talking about here, where people can now register these firearms after the fact. And of course, you have Second Amendment components because these pistols are indeed, protected arms under Heller. And now you're basically somehow making them be registered, which would not be consistent with the Second Amendment. So how's all this going to play out? And in light of that, Stephen, how will all this play out given the fact that the Fifth Circuit Court of Appeals just issued that massive favorable bump stock ruling and say the ATF lacks the authority to define bump stocks as machine guns under the NFA?
Well, you got a lot to work with as far as attorneys, whether they're doing civil cases, which have begun already, or if they're criminal defense lawyers. You've got an awful lot to work with here. You don't have much to work with if you've got just a person flat out who has a real rifle with a barrel under 16 inches and he's a crack dealer and it's not registered. You don't have much to work with there if you're a criminal defense lawyer. But this is so different. I mean, we're talking about law-abiding American citizens. We're talking about reliance on what ATF has said is lawful. We're talking about the constitutional issues. There's another Second Amendment issue here that would be in play in any prosecution, for example, is the doctrine of constitutional avoidance. If you're going to really restrict something, and is something going to be considered restricted under the NFA, when if you interpret the law the way it's been interpreted previously, where it's not under the NFA, you can avoid the issue of whether if it's a constitutionally protected arm, you can require it to be registered. Now, ATF tries to say, and this is part of its Second Amendment analysis, they say, well, look, it's not banned even if you have to register it. NFA firearms, you can't say that could violate the Second Amendment because not a problem, you can register them. But that looks into how far the government can go in restricting a constitutional right. And to say you have to go through all of this process to have something that the Constitution protects, is a pretty far out doctrine. It would never be accepted to exercise your right to free speech or the right to assemble. They're going to make you give your fingerprints and photograph and wait 6 months to see whether you can get a permit to exercise your right to assemble. I don't think so. So I hope the courts will use this doctrine if you can avoid the Second Amendment issue by holding that these items are not short barrel rifles. That's an easier way out.
So, Stephen, just a few more questions, and we really appreciate your time. This is invaluable to the Second Amendment community and to the gun space because there's a lot of misinformation out there, so it's helpful to have this information for you. But two things. What is the doctrine of void for vagueness, which I know is a standard argument that you can argue against criminal statutes, or in this case, criminal regulations interpreting statutes? How would the void for vagueness argument work, where when you look at this multi-factor Part 2 test of what is a short barrel rifle pistol brace how does this void for vagueness doctrine work, and how can people consider it in light of this sort of multi-part factor test that the ATF has made up here with their regulations?
Well, once again, keep in mind Congress defined a short barrel rifle, made or remade, designed or redesigned, intended to be fired from the shoulder, single shot for each function of the trigger. That's what Congress said. And ATF piles on all this stuff. And first of all, it's not objective criteria. It's subjective, it's vague. They say we're going to consider weight and length, but yeah, what's the weight going to be? What's the length going to be? And particularly it becomes slippery when they say, well, we're not going to consider just one of the 6 things, but we're going to consider all 6 of them. And each one of them is just filled with subjectivity and vagueness. Like how somebody else advertises something when you've never heard of that before. Or who is this community, that's step number 6, who's going to decide what is the probable use or the common use of this device. Where does all this come from even? It's invented from thin air. The Due Process Clause of the Constitution basically provides that you cannot write laws in a way that the general public cannot understand. And that's what's happened here. I don't think your typical ATF special agent would understand this stuff. And in fact, if they seize something they think is a short barrel rifle, they send it into the Firearms Technology Division, and they decide whether they think something comes under the National Firearms Act or not. And so they have a person who's an expert witness if it's at trial. And so you've got to have an expert to decide whether something is legal or not, when the law needs to be written in a way that ordinary American citizens can understand it. So that's what the void for vagueness doctrine is all about, and that's why it's required for due process of law.
Stephen, you had a huge win in the Thompson Center arms case, and that was your victory against the ATF and the Department of Justice in Thompson Center arms before the United States Supreme Court itself. And that touched on a lot of issues, everything from sort of the rule of lenity, Chevron, things like this. Can you just briefly talk to us about what is the Chevron Doctrine? Will that play a factor here? And tell us about whether or not the rule of lenity in your huge victory before the Supreme Court against the ATF and Thompson Center arms, whether or not all this will play a role in what we're about to see in the litigations involving the pistol brace litigation.
Well, so in the Thompson Center arms case, which was decided in 1992, the Supreme Court held that a pistol and parts that could be made used to make a rifle, they did not constitute a short barrel rifle as long as the long barrel for the rifle is assembled onto the receiver and the butt stock, the shoulder stock at the same time. So if you assembled it the wrong way, it would be a short barrel rifle. But the Supreme Court looked at whether this assembly of parts is a short barrel rifle just because you could assemble it a certain way. Something we argued is that a firearm is not a murder weapon just because you could kill somebody with it. It's not a weapon used in a murder unless you use it in a murder. And by the same token, these parts are not don't constitute a short barrel rifle if you don't assemble them as such. So the court looked at different aspects, different doctrines, and it's zeroed in on the rule of lenity. The rule of lenity goes back historically to the English common law. Blackstone talked about you narrowly construe statutes against the government and in favor of a potential defendant in a criminal case. And the reason you do that, if it's unclear that the law applies to a person who's a defendant in a criminal case, then you don't apply it to that person. It's just not fair. And so the court said that, okay, ATF says you can interpret it this way, but we're going to interpret it narrowly and construe it against the government and in favor of a potential defendant, because that's what's required by, again, due process. The rule of lenity stems from due process. In that case, the court did not talk about Chevron deference because the government did not argue in favor of the deference theory, which they could not because they they had a combination of parts theory that they found an old ruling that said a combination of parts to make an NFA firearm constitutes an NFA firearm. And we later discovered that in the 1968 Gun Control Act, ATF abrogated that ruling because it was inconsistent with the definitions that Congress had just enacted. For example, the combination of machine gun parts is a machine gun, but you don't have that same definition for short barrel rifle. So, but in I think in the regulation they mentioned the Thompson Center Arms case a couple of times, and they never once mentioned the rule of lenity, which decided the case. In fact, they don't even tell you that the case was decided against ATF.
Right. I did notice in a lot of the case law that the ATF cites in this regulation looks like a little bit older case law. I know they cite DeBruin and reference Heller, but they definitely, as I see it, as best I can tell, cherry-picked the cases they relied on here. But I can assure you, when this case goes to court, the federal district court judge and the courts of appeals looking at what's going on here, they're not going to be cherry-picking the law. They're going to be looking very carefully at everything, including this Cargill case out of the Fifth Circuit involving bump stocks, and, of course, the U.S. Supreme Court's decision last term in the EPA West Virginia case about the role and the limited role of executive authority and how they cannot exceed their authority under, the enabling statutes and the like. Well, Stephen Halbrook, this has been a great treat. I think people are going to really enjoy and learn a lot from you. This is just the start of a discussion and a battle that's going to go on, I suspect, with the Second Amendment gun community against the ATF. And again, it seems to me that even if you don't own pistol braces, even if you don't care about the pistol brace issue per se, we all as gun owners and Second Amendment advocates should be worried about the expanding role and scope of the supposed authority of the ATF. Because even if you don't care about pistol braces today, the reality is if they get away with this here on this issue, they're going to find other excuses to expand and encroach on our Second Amendment rights in other contexts that you might very well care about. Any final thoughts, Stephen?
Yeah, I'm a criminal defense lawyer, so I'm advising people, consider carefully what your choices are and what you should do personally. This is not something to go to prison for, and if you want to do what is in compliance with this regulation, by all means do so. You can defy it if you want to, or you can take your chances. And just remember, you want to avoid adverse consequences. All of us do. So consider carefully what you're going to do with if you have a pistol with a stabilizing brace, and talk it over with counsel, who may not be able to give you much advice based on the vagueness of this regulation. But think about it carefully. Take whatever steps you think are appropriate.
That's right. We want to make sure that everyone out there is protected and they follow the law and they're very careful. We don't want them to get crossways with the Department of Justice, because I suspect that if you're an American gun owner, this Department of Justice is not particularly interested in protecting your rights or being lenient towards you. If they have an opportunity to go get you, I suspect they will. That seems to be the trend I'm seeing, at least in the way the current administration is behaving toward the Second Amendment and gun owners. They don't think there's a right to keep and bear arms. They think at most there's a privilege. And I think if they could disarm all Americans other than government employees, I think they would do that overnight. But again, that's just my best sense of the situation. So Stephen Halbrook, thank you very much for joining us here at the Four Boxes Diner. We really appreciate you taking the time. I know it's a breaking news story, a big deal. We'll probably talk to you again in the future. And we look forward to reading your new book, America's Rifle, The Case for the AR-15. Do you want to tell us briefly what that book's all about and why someone should buy it?
Well, the controversy has been going on since 1989. It never existed before that, of so-called assault weapons. It used to be rifles and shotguns were good, handguns were bad. Supreme Court told the anti-gun people you can't ban handguns, so now they say, okay, handguns good, rifles bad. And so the book is about the law and constitutional history of rifles and what rifles have meant to Americans, and the fact that the AR-15 type rifle is the most popular rifle in America today. It's commonly used by law-abiding people for lawful purposes, and it cannot be banned under the Second Amendment. And I think you're going to see this is going on right now after the New York Bruin case. The Supreme Court told lower courts to reevaluate, to think again about what you've held before. It's like a lecture to a naughty kid, like, no, you didn't get it right, now get it right next time. And so I think we're going to see resistance still by lower courts to the Supreme Court precedent. But I think under the Bruin case, there's no doubt that the AR-15 is protected. Look at the book if you think the issue is important. I think it's very important for all gun owners, and it's called America's Rifle, the case for the AR-15.
And certainly it talks about the entire history of rifles, the AR-15, its development. As always, Stephen, you know, you're one of the foremost, if not the foremost, Second Amendment and gun historian in the United States, certainly one of the top. And it's always a treat to read your books. And so you learn so much from reading any Stephen Halbrook book. And I encourage people to go out there and get a copy and read it. They'll be a lot smarter when they're done reading the book. So Stephen Halbrook, thanks again for joining us here at the Four Boxes Diner, and we'll see you again soon.
Thank you. Thank you for having me. Take care.
Orders up. Table 2A.